In this Direct Answers video, we're going to talk about some of the Corporate Transparency Act's regulations and some of the most frequently asked questions that I've received from people. The CTA is the most important corporate law that's been passed in the last 40 years, so I figured it would make sense for me to do a video on the most frequently asked questions that I've received. The first set of questions comes to us from DL1 because he commented on one of my YouTube videos. DL1 asks, what if you create a trust, then an LLC? Do you still need to personally identify as the owner to FinCEN or other governing body? And the answer here is yes. If the trust is the beneficial owner of an LLC, meaning that it owns more than 25% of it, or the trust has substantial control over it, the trustee of that trust would have to report their beneficial ownership information to FinCEN. The next question that DL1 asks is, can you have a holding company and an LLC, then move them both into a business trust in order to avoid personally identifying as the owner to any governing body outside of FinCEN? And the answer here is no, because both LLCs and business trusts count as reporting companies because they're created by the filing of a document with the Secretary of State. And as such, both the LLC and the business trust would need to report their information to FinCEN. The next question that DL1 asks is, how does a person maintain anonymity in business and also comply with this new law? Now, this is actually a great question, and it's one that I've received a lot. When you report your information to FinCEN, only a few governmental agencies can see it. It's not available to the public. So when you report information to them, that information is going to be kept confidential. The next question comes to us from American Eagle Eyes, because he also commented on one of my videos. American Eagle Eyes asked, so if I have an LLC and I got it back in 1999, but I have not accumulated any money whatsoever through this company's name, do I need to report it? And will I be getting some kind of paperwork stating that this needs to be done? The answer here is it depends, because this entity may fall under the inactive entities exemption. And if the entity meets all 6 requirements of the inactive entities exemption, then it wouldn't need to report information to FinCEN. And when it comes to receiving some type of paperwork from FinCEN, probably not. The next set of questions comes to us from Plethora of Pinatas, because he commented on one of my YouTube videos. The first question Plethora of Pinatas asks is, what does the part where you say filing a document with the state mean? What document are you referring to? So the document that I'm referring to here is the document that forms the entity. So for LLCs, this document is the Articles of Organization. And for corporations, this document is the Articles of Incorporation. The next question that Plethora of Pinatas asks is, I'm positive that not every company is going to know about this. What happens to them? This is also another really good question. Unfortunately, a lot of companies aren't going to know about this new law. And despite the fact of not knowing this, they could be subject to $10,000 fines or 2 years in jail if they don't report this information. The next question that Plethora of Pinatas asked is, this all seems like it's a way for the government to stop foreign companies doing business in the US from hiding money and assets. Is this an accurate statement? Well, yes and no. It was one of the reasons why the CTA was passed, but Congress had other reasons for passing it too. The next question comes to us from Jack Torrance, because he also commented on one of my videos. Jack Torrance asked, will politicians be required to adhere to this law as well? Well, yes, but will they? And on top of that, if they don't follow it, will they have to pay a fine? Only time will tell there. And here are some other questions that I've received from other people. Do trusts need to register with FinCEN? The answer here is yes, if the trust counts as a beneficial owner of a reporting company. This is where the trust owns 25% or more of a reporting company, or the trust exercises substantial control over that reporting company. In all situations, the trustee of that trust must report their beneficial ownership information to FinCEN. But on top of that, if the grantor has the right to revoke the trust, they count as a beneficial owner. And if a beneficiary is the sole beneficiary who can compel distributions, they would count as a beneficial owner as well. Are there any fees associated with these FinCEN filings? The answer here is no, and this may be one of the few good answers that I'll give you. Must an attorney or an accountant submit these BOI reports? The answer here is no, but it wouldn't hurt to reach out to one before you do. Do statutory trusts and business trusts need to register with FinCEN? The answer here is yes, because they count as reporting companies. And this is because they're created by the filing of a document with the Secretary of State. Do accountants and lawyers count as beneficial owners of the company? The answer here is it depends. If a lawyer is the general counsel of a reporting company, then they would automatically count as a beneficial owner. And if the attorney or the accountant is a senior officer of the reporting company, then they may exercise substantial control over the company, and as such, they would be a beneficial owner. However, if the attorney or the accountant provides general services for the company, and it's more of an arm's length relationship, then in that situation, they wouldn't have substantial control over the company, and as such, they wouldn't be a beneficial owner. But in most cases, attorneys and accountants will count as agents under the beneficial ownership exceptions, and as such, they wouldn't need to report their information to FinCEN. Is a member of the board of directors a beneficial owner? The answer here is it depends on a case-by-case basis. Being a member of the board of directors on its own does not count. However, if that member exercises any substantial control, then they would count as being a beneficial owner. Do partnership or tax matters representatives count as beneficial owners? The answer here is no, not on its own. But if they have the 25% ownership or they exercise substantial control, then in that situation, they would be a beneficial owner, but not by itself. Is an EIN number required to report your information to FinCEN? The answer here is yes. Now, this may come as a shock to some business owners who don't have an EIN number, but you're going to need to get that EIN number from the IRS before you report that information to FinCEN. Do these BOI reports have to include historical beneficial owners, meaning people who own the company in the past? The answer here is no. It's only people who are beneficial owners at the time the reports are submitted. And lastly, how do exempt entities report? Well, since they're exempt, they don't. So for example, if they're a large operating company, they wouldn't need to report any information to FinCEN. However, if the entity doesn't meet any of the exemptions at first, they must still report their information to FinCEN ahead of time. Hold on, I'm not done yet. If you're looking to start a business, click the link in the description below and schedule a free 15-minute consultation with us. Also, make sure to check out the Corporate Direct website and subscribe to our newsletter, where we'll send you a lot of good information on corporate law amongst other things. And as always, make sure to like, subscribe, and leave a comment if you have any general questions about anything. I'll see you next time.